Hello friends, in the series on the income tax cases, today we will discuss a very important case of Bhuwaneshwar Prasad Singh versus income tax officer. This case has been decided by Delhi ITAT A bench and the date of the judgment is 24th May 2023. This case is the perfect example that because of the lack of knowledge on the part of the income tax authorities, what harassment of an assessee can happen. This is one of the best example, and how nowadays the litigant is suffering. His sufferings are to such an extent that because of the non-acquaintance with the provisions of the Income Tax Act, the assessing officers are making wild additions and they are going beyond limit. This case is a perfect example of this thing. In this case, the assessee purchased and sold shares through Demat account. When the assessee purchased the shares from the broker and the shares were there in the Demat account, the payment to the broker was made after some time. When the assessment proceedings were going on, the assessing officer did not challenge the purchase and sale of shares made by the assessee, but only on the ground that the assessee has made payment to the broker after the purchase of the shares. He held that it is not possible that the broker will accept the payment after selling the shares to the assessee. So only on this ground, the learned assessing officer made the addition of the assessee as undisclosed income. When the assessee moved to the CIT appeal, the CIT appeal gave relief to the assessee. The department moved to the ITAT, but ITAT came up with a different point that the assessee was not able to correlate the number of the shares, the distinctive number of the shares of purchase with the distinctive number of the sale of shares. There is a frequently asked questions which have been there issued by the SEBI, which clearly says that in case of Demat shares, there is no distinctive number of shares and they are fungible. Fungible means that they are interchangeable. Means the sale of shares cannot be correlated with the distinctive number of the shares purchased. So it means that the requirement of the ITAT at this level was not justified. But the ITAT on this ground remanded back the matter to the learned assessing officer to correlate the shares of shares purchased with the sale of shares with the distinctive numbers. In the second round of litigation, the learned assessing officer raised a query to the assessee to give the distinctive numbers, which the assessee was not in a position to give, because this is not possible for the assessee. There is a legal maxim that lex non cogit ad impossibila, which says that the legislature cannot impose any condition on the assessee which is not possible for him to fulfill, because in Demat form it is not possible for an assessee to give the distinctive numbers. But since the assessee was not able to give this detail, the assessing officer made addition for the second time also. This time when the assessee moved to the CIT appeal, the CIT appeal also rejected the appeal of the assessee this time. Although in the first round of litigation, the CIT appeal has given relief to the assessee. When the matter came second time before the learned ITAT, Honorable ITAT, the ITAT said that in the first round of litigation, the ITAT was not justified in remanding the matter back just to impose a burden on the assessee which was not possible on his part to give the distinctive number of the shares purchased correlating with the sale of shares. So this condition was not as per the law. So ITAT said that in the present case, since it is not possible for the assessee to give these details, and only on the ground that the payment was made after the purchase of the shares to the broker, the addition of the assessee cannot be made, and it is not a point to make the addition and treating the income of the assessee as an undisclosed income. Friends, this case is very important because this is a perfect example that how the assessee has to bear the litigation in the fiscal laws in India. Once an addition is made, the remaining life of the assessee goes in the litigation. At the end of this video, once again I am repeating the name of the case. The name of the case is Bhuwaneshwar Prasad Singh versus Income Tax Officer, and this case has been reported in 105 ITR Tribunal at page number 564. The matter has been decided by Delhi ITAT A bench and the date of the judgment is 24th May 2023. Thank you, friends.